Um, now we are finally reaching to final sessions, which is session 7. The topic of these sessions is accountability measures. Luckily, we have moderators and speakers who are all female. Please welcome them. 정리되는 되기 전에 제가 잠깐 한 가지 논의가 빠진 내용이 있어서 잠깐 소개를 드리면 우리가 이제 ODA 그다음에 비즈니스 이런 얘기도 하지만 실제 시민사회 간의 이런 협력 사업도 하잖아요. 국가 세금이나 ODA 자금이 아니더라도 이런 풀뿌리 단체 NGO들이 기금을 마련해서 이렇게 지원하기도 하는데 이때도 상당히 좀 조심해야 될 필요가 있는 것 같습니다. 특히 이제 미얀마 상황 같은 경우는 실제 이제 불교와 연결되어 있어서 그 특정 단체가 이제 자선단체 내지는 어떤 이런 개발 협력을 하는 것처럼 외형을 가지고 있지만 실제 내용은 또 이런 혐오 교육이라든지 이렇게 하는 곳들도 덜어 있다고 하거든요. 그래서 제가 비공식으로 가지고 있는 자료만 보더라도 그런 단체만 최소한 60개 이상이 있고 등등의 이런 것들이 있어서 좀 조심해야 될 필요는 있는 것 같습니다. Let me introduce the moderator for these sessions. She is Patricia Geddy, professor at Sungkyunkwan University School of Law.
Thank you. So we have the challenging session now because it's the last one. It's the one before lunch, and it's about law. But I think it's actually a very important lineup that we have today. We have experts with us here today, and it will be rewarding to sit through this. Since we know we are pressed for time, we are trying to condense the presentations a little bit and move forward quickly. So with that, I'd like to actually introduce everybody and their topics in one go, and then we'll just move smoothly if that's okay. So the first presenter is Catherine Southwick, and she is a senior genocide prevention advisor for the International Criminal Justice Leadership Program of the U.S. Holocaust Memorial Museum, as well as a doctoral candidate at the National University of Singapore. And then she will be discussing the institutional aspects of legal accountability regarding the International Criminal Court and the International Court of Justice. Next, we will have Joita Siasi speak. She's an international lawyer and founder and vice president of the Rohingya Support Group. She will speak on the legal elements of how rape and genocide are connected, which is very critical and important to the process of accountability charges. And then we will move on to Doreen Chen, who is the Free Rohingya Coalition Coordinator for International Law and has experience advising in the Khmer Rouge Tribunal. She will be bringing the discussion on how to center this for survivors in the accountability process in terms of engagement and being the driving force. So with that, let's give everybody a welcoming applause and we will continue.
Can you hear me? Okay. Well, good afternoon. It's an honor to be here, and I'll try to go relatively quickly, but mindful as well of the translation. And as a preliminary, I want to stress that what I say is speaking on behalf of myself and not on behalf of any institution with which I am currently affiliated. In any case, my goal today is to provide you with a general overview of two formal paths to seeking accountability for mass crimes against the Rohingya in Myanmar. That is the International Criminal Court and the International Court of Justice. These are two judicial bodies that adjudicate cases involving international law. Both are situated in The Hague in the Netherlands and can be invoked regarding the situation of the Rohingya in Myanmar. The ICC has been active with respect to the Rohingya since late 2017, while the ICJ has not yet been utilized. In the course of this overview, I'm going to briefly highlight some ways that the South Korean government, civil society, and others in the region can engage with these bodies, and suggest how cases at these institutions could serve the goals of a boycott campaign, as well as note some potential risks and limitations to keep in mind as you consider how to incorporate these accountability measures into a long-term advocacy strategy. Both the ICC and the ICJ are treaty-based entities, meaning that they owe their existence to the formal commitment of states to join those treaties and that constitute the ICC and ICJ. The ICC investigates and, where warranted, tries individuals charged with the gravest crimes of concern to the international community, that is war crimes, crimes against humanity, genocide, and the crime of aggression. It's based on the Rome Statute, which entered into force in 2002, which now has about 123 states parties, including South Korea, but not Myanmar. As you may know, Korea is just one of few states in Asia to have ratified the Rome Statute. And as you may also know, an eminent Korean jurist, Dr. Song Sang-hyun, served as president of the ICC from 2009 to 2015. The ICJ is the primary judicial organ of the United Nations and was established way back in 1945 under the UN Charter. Its main purpose is to settle international disputes submitted by states. Its judgments on those contentious cases are binding and final. It can also give advisory opinions on issues referred to it by the UN. Now, the ICJ comes into play with regard to the Rohingya through the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, also the Genocide Convention. Around 150 states parties have obligations under that convention to punish perpetrators, and under Article 9, a state party alleging that another state has violated the Genocide Convention, quote, shall bring the dispute to the court without delay, unquote. Both South Korea and Myanmar are states parties to the Genocide Convention, so if, for instance, the Korean government or any other state party considers that Myanmar has violated the Genocide Convention, it should bring an action against Myanmar at the ICJ according to its obligations. The ICC and ICJ reflect two distinct legal approaches to mass atrocities. The ICC is a criminal court, and its focus is on individual criminal responsibility. As a court for settling disputes among states, the ICJ's focus is on state responsibility. And these different approaches to accountability have implications for the kind of justice the Rohingya could seek. The potential outcome of an ICC trial is that one or a handful of individuals are convicted and sent to prison. The office of the prosecutor is the only entity that can investigate and bring charges against individuals at the court. The Security Council, acting under Chapter 7 of the UN Charter, can also refer to the prosecutor a situation in which one or more of such crimes under Article 5 appears to have been committed of the Rome Statute. Under a Security Council referral, the prosecutor can investigate crimes allegedly committed within a non-state party, and so a Security Council referral is the only way by which the ICC could exercise jurisdiction over crimes committed within the territory of Myanmar, which is a non-state party. As you may have heard, most experts believe a Security Council referral is not possible or likely, as Russia and China are expected to veto such a referral. After 17 years of operation, the ICC has seen, I think to date, 8 convictions and 3 acquittals. So its track record is very slow and uneven. Regarding Myanmar, in late 2017, the ICC prosecutor initiated a preliminary examination into the situation of the Rohingya. And in June this year, almost 2 years later, the prosecutor notified the pretrial chamber that she will soon seek authorization to formally investigate alleged crimes within the court's jurisdiction, in which at least one element occurred on the territory of Bangladesh, which is a state party. So based on earlier guidance from the court, such crimes could include deportation, persecution, or possibly other crimes that have an element which has taken place within Bangladesh. And if the pretrial chamber agrees that an investigation can proceed, the prosecutor can then pursue the investigation and apply for an arrest warrant or summons to appear for suspected perpetrators. If that suspect is arrested or voluntarily appears, the ICC proceedings can move forward in their logical sequence to pretrial, trial, appeals, enforcement. But generally, the entire process can take several years. And in the absence of arrest, the process can stall indefinitely. Now, while the prosecutor drives the investigation of individuals at the ICC, states parties to the Rome Statute, like South Korea, can take certain steps to support the ICC. Among other things, South Korea can participate in the ICC's Assembly of States Parties to ensure that the prosecutor has sufficient resources to carry out as thorough and efficient an investigation as possible. If the pretrial chamber eventually issues arrest warrants, Korea and even non-members can promote international cooperation in executing those warrants. Korea can also, based on its obligations under Article 7 of the Genocide Convention, to call on competent organs of the UN, can call upon the Security Council through its own initiative, a sign-on letter, or through the UN General Assembly to refer the situation of Myanmar to the ICC prosecutor. Now, even if the permanent members of Russia and China veto that referral, such a letter or a request would still send a strong signal against alleged perpetrators and serve to complicate political engagement and investment in Myanmar, while accountability for atrocities remains so limited. So, moving to the ICJ as an alternative or supplement to the ICC. A state like South Korea or any other state party could bring an action before the ICJ. Such an action would be consistent with the call of Rohingya activists, and the purpose of the convention is first to prevent genocide and to punish perpetrators in the case of violations. The duties to prevent and punish are held by states. So the entities being held accountable are not individuals, but states. This approach reflects the view that genocide is a matter of state conduct, that the state alone has certain powers to prevent genocide, and in some respects to commit it in violation, of course, of international law. Now, the state of Myanmar is responsible for the combination of laws and policies which have brought about this genocide, or the high potential for genocide, if you want to debate that, against the Rohingya group in violation of the Genocide Convention. The states parties are obligated to enforce the convention, and those disputes shall be submitted to the ICJ at the request of any of the parties to the dispute. Other states parties can act in parallel to bring their own cases, and the ICJ could join cases if it considers the matters to be substantially similar. So when one country doesn't have to go it alone, it can form somewhat of a coalition of states to support this kind of effort. I should add that states who fail to uphold the convention, states that have neglected their duty to prevent genocide in Myanmar, could also be brought to the ICJ. And this was pointed out to me by the registrar of the ICJ just a couple of months ago at a different conference. Russia and China are states parties to the Genocide Convention. They could conceivably be brought for failing to uphold obligations under the Genocide Convention because of their obstruction of any meaningful response. The parties that bring a case to the ICJ can request that the court issue provisional measures, which are immediate emergency orders to Myanmar to change certain policies, allow humanitarian access, and cease certain actions pending the resolution of the dispute. And the court, if all goes well, would eventually render a binding judgment with the orders that could address structural reforms aimed at ending persecution of the Rohingya, awarding reparations and damages, and preventing further violence. And generally, states comply with ICJ judgments so as not to be held responsible in such a prestigious forum for violation of international law. But like the ICC, this process can take several years. And in the meantime, the process, assuming a state is ever willing to initiate one, will remain public and exposed to international scrutiny by governments, businesses, civil society, and the media. How's that time? Okay. Whether or not the ICJ makes a legal determination of genocide is uncertain, it must be pointed out. In light of international courts' highly contextualized approach to these legal questions. As others have pointed out, there's a risk that Myanmar could use a finding of no genocide by the ICJ as a powerful propaganda tool. But that said, ongoing legal proceedings at the ICJ and the ICC can provide some pressure on Myanmar and the international community, including corporations, to act or at least to limit or not tolerate flagrant violations of international law. A legal proceeding has the effect of hardening facts and keeping them in the spotlight, and it is up to advocacy networks outside and inside Myanmar to determine how to leverage engagement with these institutions to sustain pressure on Myanmar's leadership to resolve the underlying dynamics that led to mass violence. A risk to avoid is that these processes become ends in themselves and become disconnected from what they can contribute towards those larger goals of sustained peace and human rights for the Rohingya and other minorities. Stakeholders should be mindful that these processes do not become excuses for inaction and divert attention from other necessary diplomatic efforts regarding Myanmar's leadership, or the crucial need to coordinate with domestic groups working to strengthen tolerance, equality, and meaningful rule of law within Myanmar's local context. So in leveraging these distinct paths to accountability, we have to remember what kind of justice they provide. To recap, the ICC punishes perpetrators and puts them in jail. The ICC does not amend the Myanmar constitution, it does not eliminate discriminatory laws, and it does not provide criminal or restorative justice with respect to the many lower-level perpetrators. It does not necessarily change hearts and minds. But while the ICC could nonetheless influence those things, it is not and does not purport to be a panacea for justice and long-term solutions. The ICJ addresses state responsibility in a comprehensive way. It does not provide the satisfaction necessarily of singling out leading perpetrators, but it is a mechanism to provide potential material relief to the Rohingya and to change laws and policies to help create a more conducive environment for security, equality, and return. So in pursuing justice and accountability, we have to be clear on what we mean by those terms and to be realistic about what those terms mean in these institutions. And above all, we must be guided by what the Rohingya say justice means to them. Thank you.
Thank you. We'll move on with Shalita Siasi.
Thank you for the introduction. Some of you may ask what an Algerian-American lawyer who comes all the way from the small town of Wake Forest, North Carolina, has to do with the Rohingya refugees. That's the south of the United States. Actually, not much. Being the daughter of a former freedom fighter who fought in the Battle of Algiers, that sets Algeria's bloody war of independence, who in 1957, at the young age of 24, was arrested and savagely tortured by French paramilitary troops, thrown in jail for 5 years, set free on the eve of Algeria's independence in 1962, and went on to work with millions of other Algerians to rebuild a country shattered by 132 years of French colonialism. That was my late father, who taught me a few things about the power of organized resistance, right of self-determination, the right to say no and to rise to oppression and domination. And most importantly, the importance of giving a voice to the voiceless and the oppressed. I was born and raised in Algeria. I was born with the slogan, be with the Palestinians, whether they are wrong or right, with South Africa apartheid, and today with the Rohingya. So that's what I'm here for. I don't have the experience that so many of my brothers and sisters have working on this, to their credit, for years. I was walking through a terminal with my little one and my husband going to celebrate Eid al-Adha in August 2017, and I saw on the TV horrible images of waves of human beings crossing international borders. By the time I went back to Wake Forest, I was filing articles of incorporation to set up a nonprofit. What we do, we raise awareness and beef up, we try to fundraise to beef up the humanitarian response capacity. This is both a timely and important discussion. It's important because this is an ongoing genocide. As a lawyer, we usually talk about genocide retrospectively after the fact. This is happening as we speak. So it's important to sustain a pressure, keep the cap, keep talking about it until the Rohingya tormentors are brought to book. Especially that those who are responsible for these crimes have gone largely unpunished. And they know that their borders and their government will shelter them from any type of accountability. It's important because August 25th, tomorrow, mark a grim anniversary. It's been a brutal turn in a decade-long of sponsored violence, oppression, a system of apartheid against a helpless community for no other reason than for being Muslim Rohingya. Look, this happened in August 2017 when we in America saw numbers of women emboldened in the post-Harvey Weinstein era come forward with allegations of rape and sexual assault. But look, these were, for the most part, the white, highly educated or educated, financially well-off, soft-spoken women who were able to lawyer up their cases and claim their rights. Same time, different place. Across the globe, the Rohingya women, most of them women, girls as young as 7, be tied by their hair and hand to trees and gang raped. So we need to keep the cap. That's why this is an important discussion. It's timely because 70 years ago, the UN General Assembly ceremonially adopted the UN Convention on the Prevention and the Punishment of the Crime of Genocide. So never again the atrocity that happened during World War II happened again, but never again has been a broken promise. Timely again because 20 years ago, an international criminal tribunal, that is the International Criminal Tribunal for Rwanda, said that rape and sexual violence can be a constitutive act of genocide. So this is very timely. And what I really wanted to do I want to commit to the time I have, 10 minutes I gave to myself. 2 points. Via sidebar, I'd like to explain, we have been saying that this is widespread, systematic, endemic sexual violence and rape, but why? And why it is met with so much impunity? And 2, the second point I'd like to make, and I'll wrap up, is how do we link rape and genocide in international law? And we do have the source of international law, as outlined in Article 38 of the Statutes of International Court of Justice, laying out that link. So on the first point, look, the 20th century has seen a shift from traditional conflict to domestic conflict. We went from conflict that opposed sovereign state to conflict that opposed, on one hand, a sovereign state, and usually a non-state actor, Daesh, Al-Qaeda, Boko Haram, you name it. Within that shift, and in that context, the prosecution of international crimes in the home jurisdiction becomes very challenging and sometimes impracticable. Within that shift, we saw the burden of warfare has shifted from armed forces to civilian population. You know, the bulk of casualties today in today's conflict are among civilian population. You know, writing for the New York Times in December of last year, op-ed columnist Nicola Kristof reported that the common casualties of the Yemeni war is not a soldier dying of a bullet, but a child dying from malnutrition. As you may know, between 2015 and 2018, 85,000 children died in Yemen from lack of food. Let me repeat that number. 85,000 children died in Yemen from malnutrition within a 3-year period. Between August 25th and September 24th, that's 4 weeks, 6,700 Rohingya were killed, 730 of them were children. These are mind-numbing numbers. Within that shift, we saw a rise in the use of sexual violence as the weapon of choice in armed conflict. In Bosnia, Serb forces, by ethnically cleansing women through ethnically motivated rape and forced impregnation, they were ethnically cleansing territory, which is the ultimate military goal. And to your point, actually, it's 3 birds with 1 stone. You know, you deflect international attention. You know, after all, it's not extermination through mass killing. It's only rape. 2, you cleanse territory because the rape victim never come back to where they were raped. And 3, you cause massive mass displacement. So it is extremely effective. It comes at a very low cost or no cost to the perpetrator with shockingly effective results. And that's why it is very much the weapon of choice today in an international conflict. Now, how does rape connect to genocide? The first one is international. We have 3 sources: international treaties and convention. We have the customary international law, and 3, the decision of international courts. So in terms of international convention, 2 international conventions that I will be citing, the Convention on Genocide and the Rome Statute. So you have Article 2 that lays the foundation of how genocide works. You need a targeted group, you need 1 or more of the acts under the categories outlined from A to E, and then 3, you need intent, which is the most complex and legal and thorny issue in charging genocide. But the interesting thing and more pertinent to rape and sexual violence is that the Genocide Convention embodies the idea that the regime can exterminate or can kill with acts short of killing, meaning if you're causing serious bodily or mental harm to members of the group, you can end up extinguishing that group. And one, I think, fact that needs to be outlined here is that the genocide is a crime that has gender implication. Why? Because men usually are targeted for killing, while women are subjected or are victims to other type of serious violations over a longer period of time. That's why, out of the 1 million refugees, half of them are women. Why? Because men don't survive genocide, women do. And that's a key fact, because they are the only ones who are left to say where, when, how this crime happened. And that's why they need to be supported. They are the ones who will be telling the stories. They need to understand the consequences of the crime that have happened. The Rome Statute is another international treaty that does link rape to genocide, actually explicitly in the element of crime, which recognize that rape can constitute genocide. The customary international law is another source of international law because rape has been recognized as a grave breach and a war crime in many resolutions in the Geneva Convention and Additional Protocol, and that is indicative of a uniform practice and the corresponding opinion juris making rape and sexual violence a crime, a principle of customary international law. The courts, you will see the difficulty in bringing a charge of genocide or rape in the many judgment. First, the Rwanda tribunal, there is a historic judgment called Prosecutor via Kiesu that does end up by recognizing that rape can constitute genocide, but mind you, the original indictment did not include sexual violence, despite gruesome acts of sexual violence that have been perpetrated against Tutsi women. And I'll give you an example how genocide or raped worked in Rwanda. In Rwanda, the Tutsi government, in one instance, they released thousands of AIDS patients from hospitals to make battalions of rapists. Tutsi women who were being raped were also infected with the HIV virus. Some of them died, but some of them ended up surviving, but later died from AIDS. And that's called condition of life genocide. Basically, you inflict condition of life calculated to bring the destruction of a group. I think in terms of accountability, my take is that the ICC has, as a lawyer, I'm a fan of the ICC. I believe in international institution, but in this particular case, I think the move from the OTP and the prosecutor herself was extremely innovative. I think whoever read that brief for the request for preliminary examination, I think it was a fantastic piece of legal writing because they had to use, legal imagination to extend the jurisdiction of the court to that extent. But that's one school of thought, and I'm very supportive of the current proceeding, although I believe the pretrial chamber in September 2018 said to the OTP request, yes, of course, you do have jurisdiction. As a matter of fact, they paved the way to a wider range of inquiry in addition to deportation, persecution, and other crime. And you've got to say this, the second recommendation, do it quickly. It took the OTP office 1 year. I mean, they just requested actually an investigation. And to Catherine's point, look, by the time they get to the confirmation of charges, which is a mini trial in itself, it's going to take. So I don't see any, personally, that's on my own view, I don't see any arrest warrant being handed out anytime soon. And you've got the whole chain of command. It is extremely complex. So that's ICC. Now ICJ, when I think ICJ, I'm upbeat, but in the back of my mind, I'm thinking Bosnia v. Serbia. So on Bosnia v. Serbia, it was a devastating blow to the Bosnian Muslim. With everything that they have been through in Srebrenica and elsewhere in Bosnia, they had also to endure failing on that request. I think one of the biggest mistakes that Counsel for Bosnia did is not to retrieve the case before the judgment on the merits. And the other thing is time. I mean, ICJ is known to be an institution that works at a very leisurely pace. It took Bosnia 14 years between the time they filed the complaint to the judgment on the merits. They had a lot of issue during the case, so the case had to be kind of slowed down, but it took them 14 years. Now, look, I want to conclude by, we heard a lot, we don't have a solution. I don't have a solution, I wish I do. But here's a wild idea. While evidence is being gathered by the UN mechanism, the national impartial independent mechanism on Myanmar, while jurisdiction is being engaged at ICC, ICJ, I think we need to come up with an alternative in the meantime, while we're waiting for these mechanisms to produce something. And that is, and I can't think of a better example, we need to look at precedent and example, than the Hissène Habré case. Hissène Habré was a former dictator of Chad who tortured, raped his women, personally raped some of the victims in his palace, presidential palace in N'Djamena. It was the victims who brought him to justice. Hissène Habré actually, whoever who saw his trial, refused to appear in court. And the judge says, no, you come here. So he came kicking and screaming. And the victims were there. It took them 20 years. They worked under the leadership of the brilliant and indefatigable lead counsel, Jacqueline Moudaina, who put up a masterpiece of strategic litigation. But what she did, she was able to link the work on the individual case to outreach, PR, and she put the victims at the center. She trained herself, victims of rape and sexual violence, in understanding, in articulating the crime that have been committed against them. I mean, just read. Brody was the Human Rights Watch guy who worked with her, but there is a huge report on how they put up the, look, they went, the victims, not the lawyer, went to London to understand how the British authority acted on the Spanish arrest warrant in the Pinochet case, took note, and took that to N'Djamena to start the case. It took them 20 years. It's resilience and patience. So I see something like that. I know it's a different case. There is some similarity, and actually one major resemblance is that sexual violence was rampant in the Habré case, and it is a central component of the genocidal policy waged by Myanmar against the Rohingya. So on that, maybe what we can do, and I'm talking as a lawyer here, civil society, Professor Bose was talking about a mass movement. I see that happening, but as a lawyer, I think what we need to do is have a transnational coalition. There's a lot of effort going on everywhere, in the United States, in Canada, in London, but coordination is non-existent. We need to coordinate, and so we have some sort of network where we can build the factual case, not only the legal case. By the time we get to having a tribunal that is going to try these, whether ICJ or ICC or another ad hoc tribunal, the victims will be ready. Thank you.
Thank you so much. I think we will revisit many of the points you raised. Doreen Chen, next.
Thank you so much. It's a real privilege to be here. It's also a special privilege to be the last speaker of the conference. As my opponents in the courtroom and my husband would tell you, I love having the last word. So, without further ado, I've asked every Rohingya survivor I've met what it is that they want. And without exception, each and every one has identified accountability and justice as a key priority. Often, it's their number one concern. Now, this is comparable to the Cambodia context, where I've worked on accountability for a decade. In 2016, a large-scale study by the Open Society Justice Initiative found that for Cambodian Khmer Rouge survivors, accountability was and remained important. And this was so even 35 years after the fall of the Khmer Rouge and 10 years after the official accountability process began. What's equally striking, however, is that the study also revealed a significant drop over time in Cambodians' interest in that accountability process. That is the joint UN Cambodian government-run Khmer Rouge Tribunal. While most remained theoretically supportive of the process overall, they also criticized it as politicized, corrupt, and slow. And more importantly, they were ignorant of what the process involved and indifferent to it anyway. Now, in my view, official accountability processes will likely always be valuable to the victims on whom they intend to focus. However, perhaps this is more about the idea of accountability that these processes represent, rather than the actual justice that they render in practice. For me, based on what I've seen, Cambodians' lukewarm indifference to the Khmer Rouge Tribunal and its seeming irrelevance to them stems from three main things. First, their expectations about what accountability can do are not managed. Second, they have limited access to information about it. And third, and by far the most important, the process largely treats them as objects to be acted upon rather than as agents who ought to continually and fundamentally shape that process. Now, in Cambodia, we find that these factors are often better addressed by the many informal or shadow civil society initiatives that have been created alongside, parallel to the official process, filling in gaps or addressing shortcomings in that process. And the Open Society survey data actually supports this. Respondents were found to have mostly praised civil society initiatives rather than the official process, and they highlighted in particular, just for your interest, mental health support services and memorialisation efforts. So how is all of this relevant to the Rohingya question and to other mass atrocity crime survivors around the world today? Well, what it shows is that it's vital that we start as we mean to go on, as the saying goes. And what I mean is, we need to ensure that our approach from the very beginning is one that guarantees that down the long accountability road, Rohingya feel fulfilled by an accountability process that is actually of relevance to improving their lives. So how do we do this? Well, let's look at some past experiences like Cambodia and see what lessons we can draw from them. And the first lesson is that we need to manage expectations from the start. Speaking not only as an accountability practitioner, but as a victim myself, what I believe is that what most victims want is to be made whole again, as if they had never been violated at all. Unfortunately, accountability can't achieve this. Nothing can, in this life at least. And this needs to be acknowledged and accepted upfront. If not, no accountability process will ever have a chance of being satisfying to survivors. Now, beyond this initial question, what expectations will need to be managed will depend upon the circumstances of each context. So, taking Cambodia as an example, some of the features of the Khmer Rouge Tribunal that have proved dissatisfying to survivors have been these. Firstly, that it could not impose the death penalty because it's abolished in Cambodia and considered a gross violation of human rights. Secondly, that the tribunal, like many international tribunals, does not offer individual reparations, only collective ones. And thirdly, that the tribunal does not offer monetary compensation. Now, just speaking about monetary compensation for a second, indeed, where such compensation can be offered, for instance, at the International Criminal Court, that money isn't coming out of perpetrators' pockets anyway. It's coming out of a trust fund funded by states parties to the court. So if part of the motivation for compensation is to punish perpetrators economically, accountability might actually disappoint in that sense. Moving to another point. In my experience, survivors also hope to put senior leaders or those most responsible on trial to assess their individual criminal responsibility, to extract a direct apology or an explanation about what happened, and oftentimes to impose a jail sentence. This requires leaders to be physically involved in the process, meaning that they need to either cooperate or be arrested. And this, for example, is the opposite of what happened with our Permanent People's Tribunal on Myanmar. There, as the Myanmar government ignored the invitation to participate and there was no way to force them to do so, there was no defence presented in the end. Now, to fulfil this physical presence requirement, unfortunately, regime change, if not a total geopolitical shift, is likely needed so that the alleged perpetrators are more vulnerable. And in Cambodia, at least, this is one reason why the accountability process took so long to get underway at all. Next. If the hope is to have an official institution give a determination about the occurrence of mass atrocity crimes, we also need to explain that this may result in politically compromised outcomes depending on the positions of the relevant political powers who influence that process. In Cambodia, for example, this has meant that there's been an effective ban on summoning by far the most important witnesses to testify. And these are people who are current top leaders in the Cambodian government and military and were former senior Khmer Rouge themselves. The geopolitical perspective also gets sidelined in the Cambodia process, which only takes a limited look at what other countries did and how they were involved in what happened. And this means, obviously, that the truth that is uncovered is incomplete in hugely significant ways. And one final example of an expectation to be managed, the most important one, I think, is for an accountability process to enable survivors to tell their story their way. Now, in the Cambodia Tribunal, as in many others, survivor stories are primarily relayed in an adversarial question-answer approach that involves what we call examination in chief and cross-examination. If any of you have watched Law & Order or other TV legal dramas, it's essentially what you see there. Now, from my personal experience as the one asking the questions, what I can say is that, to me, this approach results in piecemeal storytelling, in the narrative being driven by the questioner and not the survivor, and the focus being on whatever the questioner needs to prove rather than what may matter most to the survivor. It's also usually a linear approach to narrative and memory, which doesn't always sit well with Asian approaches to storytelling or indeed to the way that victim memories work at all. And in Cambodia, all of this unfolds in what I like to call a giant fishbowl of a courtroom. So you have very blindingly bright lights, you have video cameras, you have 40 or 50 people watching in the courtroom in robes and in suits, and then 400 more people behind you in the public gallery, not to mention the whole thing is often broadcast on television and radio. So, in short, it's incredibly intimidating for anyone, but especially for people who are unfamiliar with this kind of environment, who may not have been prepared in advance, unfortunately, that seems often to be the case, and who are brought in to testify about highly sensitive or traumatic events, for instance, personal accounts of sexual and gender-based violence. Now, moving on to the second lesson we can draw from past experience. That is this: we must continually disseminate as much information as we can about accountability. It's obvious from much of what I've already said that this is the only way to overcome ignorance in the process and a critical way to avoid the kind of indifference in the process that we've unfortunately seen develop in Cambodia. Now, in promoting access to information, we also need to push back against the paternalistic idea that since some survivors don't have formal education qualifications, they're somehow incapable of understanding the information, and thus they need to be told what to think rather than be given the space and the resources to decide on their own. I want to be clear about this. In my view, survivors have by far the most important qualification to participate and lead accountability processes. And that is, it is they who experienced the very events over which we seek accountability. Now, as much as some of our colleagues might like to think otherwise, this is far more important than academic degrees, ability to use big words, or fancy job titles. It's incumbent on us as carriers of the relevant information to adapt its delivery to survivors' needs. And all of us in this room are doing so. I know I'm preaching to the converted here, but so much more needs to be done, and by so many more people. So turning to the final lesson that I think we can learn, and the most important one here, that lesson is this: survivors, like the Rohingya, must truly be driving any accountability process for it to succeed. As Yasmin, as Mabrur talked about, it is not appropriate that we just ask a few Rohingya leaders to endorse accountability options that we believe to be the best ones. Even if we have full knowledge about what happened to them, it's not appropriate that we determine on their behalf how accountability for their suffering should be pursued. Equally, it's not enough that only a few Rohingya community leaders are at the table, and many people have already said this. Not only must the relevant information reach a larger and more representative sample of Rohingya, these people need to have their own seat at the table as well. And for example, and as many speakers have said, Rohingya women and children have experienced crimes in a unique way. And they are the ones best placed to ensure that accountability appropriately and adequately addresses their needs. In addition, while we may have the best of intentions in terms of trying to achieve accountability as soon as possible, and I'm fully supportive of the ICC and ICJ approaches, for example, so this is not knocking them, what I want to say is that it's nonetheless unimaginative of us to assume that our only suite of options are the accountability models which have come before us. Now here, just to take something from left field, we can draw inspiration from the design world. Design theorists suggest that the first step should not be to design the thing right, but to design the right thing. And that is, we need to first consider what the purpose is, and then decide what the proper solution is, if the accountability model we've selected is the right fit. And now, before we say that we already know what that purpose is and that reflecting on it is a waste of time, I think we need to check our assumptions here. We thought that in the case of Cambodia, but the indifference that we're now seeing suggests that maybe we were wrong. Or maybe expectations changed over time, or maybe both, or maybe neither of those things. Who knows? So how do we know? We ask those for whom we seek accountability at all. In this case, we provide as many Rohingya as we can with full information delivered appropriately. We give them full autonomy to tell us what it's all for, what they want, what matters to them, what doesn't. And then we workshop with them to see if what exists can fit that, if we need something new, or if, and this is just my suspicion, what we need is to try a combination of different solutions, as Catherine was talking about, since we're trying to address a range of different interests. And it's equally important that we continually ask these questions along the way so that we can update our advocacy and push for ongoing adjustments to accountability processes accordingly. Designers call this kind of approach human-centered design. And as the term suggests, it's not rocket science, it puts the human at the center as the core agent rather than as an object on the sidelines. This is what we at the Free Rohingya Coalition are trying to do, to ensure that accountability is truly for and by Rohingya. We hope that you will join us. Thank you very much.
Thank you. So we will take 2 questions. Let's keep it short. And if you have longer, more engaging questions, I think we can save that for after the presentation. Okay. So 1 question back there.
Thank you. Thank you very much for extremely educational talks. I just want to pick up on what Catherine said about making the link between, very technical legal activism with the central message that we want to transmit from this conference. Because we need to see the different legal possibilities, whether going with the existing venues, ICC, ICJ, or other ad hoc tribunal that may come in existence in the future, with the wider movement for justice. It's very, very clear that justice will not be served on a platter by UN member states, whether it's United States or China or Russia or South Korea. So this is, I'm not going to ask a question, I'm going to make a strategic suggestion. That is, as I understand, the Korean society is made up of, a substantial segment of Korean society is made up of Christians of different denominations and Buddhists. What if the interfaith communities direct their demand on behalf of the Rohingya, echoing what the Rohingya want in the form of legal justice? In other words, if interfaith communities come together as a coalition, write a formal letter to the President Moon, and write another formal letter to the Speaker of the Parliament or representative body within Parliament that deal with Korea's foreign affairs, and ask them why South Korea, as a state signatory to the Genocide Convention, is failing to discharge its treaty obligation. I had the privilege of going to Malaysia with the team of international legal experts, some of whom are in this room, including Catherine and Kim Al. And we briefed the foreign minister, and but prior to that, I also had the privilege of having one-on-one meeting with the Prime Minister, Dr. Mahathir. And both of them pledged to pursue the legal action challenging Myanmar at the ICJ. But because of the domestic complications, they have not undertaken their pledge. But I see South Korea as a #1 candidate, considering the fact that South Korea is an extremely active participatory type of democracy among all Asian countries, including India, Japan, and Southeast Asian countries. So I think if Korean civil society will initiate that, writing 2 letters, I think that could trigger, massive domestic response, because you are showing the example, setting the example that Asia is no longer going to be a dark continent where billions of Asians look the other way when another genocide is being committed on another Asian, the fellow Asian community. I think that will also have a major implications for these Korean investors that are currently financing rape and investing in genocide in Burma. And finally, we have a situation where the court has not arrived while the victims are still being persecuted. Gregory Stanton, a leading genocide scholar and former State Department official, said by the time the court arrives, all victims are dead. But our problem is the victims are dead and victims are dying slowly, and the court has not arrived. we need to make sure the court has arrived and investment and financing in the Burmese genocide stop. And I would appeal to South Korean civil society to write those 2 letters. Thank you.
Thank you. We have one more here.
Thank you. I've got 2 questions, if it's okay. The first one, in response to the Chad case that you mentioned, I think one of our colleagues, Daniel Taylor from Australia, also mentioned this at the New York conference of possibility of putting victims at the heart of a potential trial and using their statements to go forward. It also took 25 years for that accountability. So how is that any better than the ICC and the ICJ? And is there any way that can be speeded up? Is there a quicker route of that? What are the things that stop that from being, kind of sped up? And the second one is to you, Doreen. You mentioned in the middle of your wonderful presentation about regime change and that seismic shift. Do we have any legal instruments that can allow for that to happen? Because as you mentioned, I think you mentioned as well, Catherine, that ICC trials will never ever result in any kind of political change. It's just an individual accountability of the person who's going to be standing trial. So is there anything more than that?
Great, yes. Could you use the microphone for the translation?
Thank you, Ahmed, for your question. Look, I cited the Habri case, and I said there are differences. Because, as a lawyer, I think when you attend these kind of conferences and gathering, what people take away, okay, so that's all good, but how do you do it on the ground? So it's good to give examples and kind of precedent. The Habri case is different, but the idea here is to bring the victims from the outskirt to the center of the justice struggle. That's why I was thinking about the Habri case, because from the outset, counsels for the victims got them involved. First of all, they did a lot of training and education directly with them. I'm not talking about alternative to ICC. In addition, I said, while these jurisdictions are being engaged at ICC, ICJ, maybe an ad hoc tribunal or regional tribunal, we've got to prepare the victims and have them build a factual case, meaning set up more victim association, more victims groups, have victims have a seat at the table when we are more Rohingya victims. So they understand and know how to articulate, not from a legal point of view, how we put these cases together. By the time you get to trial, whether ICJ or ICC. Look, ICJ will have, if the case moves forward, you're going to have a fantastic forum in which, first of all, Myanmar will have to come and explain itself. So far, they have been issued blanket, pathetic, tiring denial to what it is, a painful truth. So if we have an ICJ case, you're going to have victim testifying. You don't wait for trial to prepare the victims. You've got to start preparing them from now. And that's what Jacqueline Modena did. I mean, she worked tirelessly. She was a victim in an assassination attempt, did not give up. And they worked for 20 years until that extraordinary African chamber in Dakar was up and running, and they were there. Khadija Zidane was one of the witnesses who was a rape victim, and Hassan Abri raped her 4 times in Presidential Palace himself. And she was there to testify and told him how she felt when he did it and how she was feeling that day. It's going to take a lot of resources and but because of these institutions who are working at a very slow pace, I think we need to do something. We can't leave victims to their own device. So that's why I mentioned the Habri case.
Okay. I would like to build on what Zarni's intervention and to encourage Korean civil society and civil society around Asia to recognize the wider context and what is more at stake beyond the atrocities against the Rohingya. I just started working for the Holocaust Museum, and one of the challenges or questions that is facing the institution is how do you make the Holocaust relevant to future generations now that survivors are dying off? And it's interesting to me to hear Zarni in his presentation invoke the Holocaust as something that is relevant in thinking about what's happening here. But we also have to think of our time as a time to kind of reframe and reappropriate what those principles mean for our time and the future. I think that right now, the U.S. leadership on these issues is somewhat adrift, and who knows what will happen in the next presidential election. And there is a moment here that I see in Asia when we think about this century becoming the Asian century, where it's important to think about the rise of Asia, both in terms of economic power and political power, but also in terms of consciousness and conscience. And in order for there to be a powerful region, it also comes with consciousness of these issues and a reflection on past atrocities in the region and a proper reckoning with what is happening and what it means for what's happened to the Rohingya means for societies in this region and the world going forward. So I just ask that, Taiwan recently had this wonderful legal victory on LGBT rights. Hong Kong has shown a tremendous momentum on democracy promotion. A year ago, we thought that movement was dead, frankly. And this challenge is begging for, I think, Asian consciousness to rise up and to say that we're not going to go into the next century having abdicated our responsibilities that grew out of the aftermath of the Second World War. Thank you.
I get to have the last word again. Yay! So a couple of different points here. So first of all, I wanted to go to Zani, your comment. What I took from your comment actually was used the phrase interfaith efforts. And it made me think of something, and that is oftentimes I've noticed that when we're talking about accountability, people raise the idea, but there's a finite limit to the amount of resources, the amount of appetite there would be for these things, and that, therefore we have to choose the first among equals and only go with that because that's the reality we face. And when you mentioned the interfaith efforts, that made me think of this point, which is, I don't think that that's true. There are different buckets of resources, and faith-based resources is one separate bucket to the bucket that's often funding the kinds of accountability processes that Catherine and Joida were talking about. So I don't think that that's the case at all. And in any event, and I think we've all said it matters to just throw it all at the wall. Try everything at this point. There are so many different pathways to justice, and justice is such a multifaceted beast anyway. There isn't one process that would satisfy all interests and needs, so why don't we try it all? And for that matter, I guess a related point was, I think again, we're preaching to the converted here, but I think it matters so much that all of us are engaged in this and that we're not all just sitting back and thinking, oh, the experts will take care of this, or having too much faith in lawyers. I'll leave that there with you. So yeah, that's all I wanted to say about Zani's comment. Mabura, to you, for the first point about the Harbury case, actually, what I wanted to say is, I think another misnomer that we hear often when we talk about accountability is that it's all this big waiting game for a judgment at the end of the process. What's interesting, the Open Society data on Cambodia also found that actually the process matters so much more than the end result. The judgment is by the by. They're never going to be perfect. They're working under a time limit. There's so much pressure from General Assembly to wrap things up and whatever. And, humans have limits in terms of summarizing this incredible suffering. So that process matters more. That process can start straight away. It is starting straight away. Kinam and others are working on it already. That is hugely important, I think, documentation efforts and coordinating those documentation efforts, as Joita was talking about, rather than having them be competing. That's all building towards something. And you can see that in Cambodia. The foundations were laid fundamentally by civil society efforts long before the tribunal even got underway. So that's what I wanted to say about that. And the last point about regime change, I think Catherine answered your question. I think that the main tool here is the ICJ. And again, we're not waiting for the 14 years for the judgment. The mere fact that an action would be brought against the ICJ or that there's a letter sent calling for such action to be brought against the ICJ, that taints the regime in question. And I think that, little by little, would, I would hope, corrode their position, or at least, I think as you were saying, make them think twice before they act. So.
Thank you so much. Okay, it's working now. Okay. We had an amazing and powerful session, I think, because usually we understand the power of legal institutions, but also the very limitations of legal institutions and how we can regain some of that credibility by actually centering survivors in terms of leading and engaging with these legal mechanisms. And I think one point that keeps coming up, especially with human rights lawyers, is that these processes take so long. But we have to remember, in the context of years and decades and across different countries and borders, that with each of these institutions, the following institution, the next cases, they accelerate, they accumulate, and they accelerate. And so we reach further now with this case than we did a couple decades ago with Rwanda, for example. And so this is an ever-going process, and the consciousness raising happens with the process itself. So for us, it's about managing expectations, not pinning hope on the end of a court decision, but realizing that much, much more happens before that point arises. So I will end with that and hand over back to the conference organizer. And one more time, if we can have a very grateful, warm applause for our contributors.
Thank you so much.